Second, 5 second, start. Prisoner reforms and protection of life and personal liberty of inmates. A petition was filed before the Supreme Court to issue necessary directions relating to reform of prisons in the country and for protection of right to life and personal liberty of the inmates guarantee under Article 21 of the Constitution of India. Prison reforms have been the subject matter of discussion on decisions rendered by the Supreme Court from time to time over the last 35 years. Unfortunately, even though Article 21 of the Constitution requires a life of dignity for all persons, little appears to have changed on the ground as far as prisoners are concerned. And once again, it is required to deal with issues relating to prison in the contrary and their reform. It is clear that in spite of several orders passed by the Supreme Court from time to time in various petitions for one reason or another, the issue of overcrowding in jail continue to persist and apart from anything else appear to have persuaded Justice R.C. Lahoti to address a letter of the Chief Justice of India on the specific issue of overcrowding in prison. The petitioner, like all human beings, deserve to be treated with dignity. To give effect to his some positive direction need to be issued by the Supreme Court. The under trial review committee in every district should meet every quarter, and the first such meeting should take a place or before 31st March 2016. The secretary of the district legal services committee should attend each meeting of the under trial review committee and follow up the discussion with appropriate steps for the release of under trial prisoners and convicted who have undergone their sentence or are entitled to release become of remission granted to them. The under trial review committee should specifically look into aspects pertaining to effect implementation of section 436 of the Code of Criminal Procedure and section 436A of the Code of Criminal Procedure so that under trial prisons are released at the earliest, and those who cannot furnish bail bonds due to their poverty are not subject to increase only for that reason. The under trial review committee will also look into issue of implementation of the Prohibition of Offenders Act 1958, particularly with regard to the first time offender so that they have a chance of being resorted and rehabilitated in society. The members secretary of the state legal services authority of every state will ensure in coordination with the secretary of district legal services committee in every district that an adequate number of competent lawyers are impaneled to assist under trial prisons and convict, particularly the poor and indigent, and that legal aid for the poor does not become poor legal aid. The Secretary of District Legal Services Committee will also look into the issue of the release of under trial prisoners in the compoundable offenders, that efforts being to effectively explore the possibility of compounding offenses rather than re- requiring a trial to take place. The Director General of Police, Inspector General of Police in charge of prisons should ensure that there is a proper and effective utilization of available fund so that the living condition of the prisons is commensurate with human dignity. This also includes the issue of their health, hygiene, food, clothing, rehabilitation, etc. The Ministry of Home Affairs will ensure that the management information system is in place at the earliest in all the central and district jail as well as jail for women so that there is a better and effective management of the prisons and prisoners. The ministry management of Home Affairs will conduct an annual review of the implementation of the Model Prisons Manual 2016 for the which considerable effects have been made not only by senior officers of the Ministry of Home Affairs but also prisons from civil society. The Model Prisons Manual 2016 should not be reduced to yet another document that might be revived only decade later, if at all. The annual review will also take into consideration the need, if any, of making change therein. The under trial review committee will also look into the issue raised in the Model Prisons Manual 2016, including the regular jail visit as suggested in said manual.